All right, we're doing this all over again because why wouldn't I? All right, so let's do this again. And we're going to do paste, paste, and pin. Okay. All right, so for those of you who missed it, who missed what I said originally, this was filed on the 21st. This has already been argued. I'm just doing this to kind of show people that he doesn't understand what he's doing. What I did in the prior stream was I accidentally showed some contact information, and so I don't want to do that. And what I pointed out was this is the reply to the state's response to motion to dismiss aggravated harassment for vague overbreadth and the First Amendment. And it's a challenge for vagueness and overbreadth is a First Amendment challenge. There's no just general First Amendment challenge. It's you're challenging it. It's a First Amendment challenge for vagueness and overbreadth. And in order for something to be vague and overbroad, it has to catch a substantial amount of protected First Amendment speech in it as written. So an attack for vagueness and overbreadth is saying that, yeah, okay, totally, I did a bad thing that isn't protected by the First Amendment, but the statute itself violates the First Amendment to the point where even though I didn't violate the First Amendment, the statute itself, or even though I did unprotected speech, the statute itself will catch protected speech, and so the statute is overbroad. I don't know if that's understandable. There's two ways you could attack it. You could attack it as violating your First Amendment right, i.e., as it is as applied. It's an as applied attack. My speech was protected First Amendment speech. Or you attack it for being vague and overbroad, meaning my speech wasn't First Amendment protected speech, but there's speech out there that this is going to catch, and a substantial amount of the speech that's out there that this is going to catch is First Amendment protected speech. So there's tomatoes. There's never any. I don't do ads, so you can always watch this later. But I thank you for stopping by, tomatoes. So he's going to have to figure out if he is doing this as applied or as a overbroad challenge. So he respectfully moves the court to grant the motion to dismiss and dismiss counts 1 to 13 in this case number. Now, counts 1 to 13 are not all of the aggravated harassment. I think only 5 or 6 of them are aggravated harassment. I think there's a stalking charge in there, and I think there's like 5 or 6, maybe 7 misdemeanor harassment. Misdemeanor harassment. So not felony harassment, not aggravated harassment, but misdemeanor harassment. So, it's best practice is to state in your title, your reply to state response, right? To state what you want from the get, and have your caption reflect what you're actually asking for, and not just ask for it in the body of the moving paper. Now, this is a reply brief, and all of this stuff should have been in the actual motion, which, so the way it works is you file the motion, your opponent files their opposition to your motion, and then you get to file a reply brief. Now, your reply brief isn't supposed to raise any new substantive arguments. It's supposed to literally be just replying to the arguments and objections raised by the opponent in their opposition. So nothing here should be new. Now, it is new, but whatever. The court has dealt with this, and I'm just telling you what best practices are. Mr. Miles files his reply to state's response filed April 18th to further clarify Mr. Myers' position and the relevant facts and authorities. Mr. Myers now files the following memorandum of points and authorities. Number 1, statement of facts. The single most important fact that has been consistently overlooked by the state is this: And then he proceeds to ask a question. Now, again, best practice is you don't ask questions, you state facts. This is titled Statement of Facts. One would expect, one would assume that the natural course of progression would be that you would state facts. And sovereign citizens and pro-pers always, they can never seem to help themselves but ask questions instead of stating facts. It's irritating. He says, why would a state of Arizona employee with a loyalty oath pursuant to ARS 28-231 be, quote, alarmed, annoyed, humiliated, or mentally distressed, end quote, when contacted in their official capacity, when the loyalty oath specifically states the following? Now, okay, let's read it. Quote, I, Shannon Walker, do solemnly swear or affirm that I will support the Constitution of the United States and the Constitution and laws of the state of Arizona, that I will bear true faith and allegiance to the same and defend them against all enemies, foreign and domestic, and that I will faithfully and impartially discharge the duties of the office of the Board of Regents according to the best of my ability. So I affirm. ARS 28-231. Well, let's look at that. Let's take the time to read this and see where she says I can no longer be alarmed, annoyed, humiliated, or mentally distressed. Where does it say that in there? Oh, wait, it doesn't. It doesn't say anything along those lines in there. It says that she'll support the Constitution of the United States. Great. She'll support the Constitution and laws of the state of Arizona. Great. What does support mean? What does it mean? I mean, support seems like a pretty vague word, right? I support the Constitution. Well, what does that mean? If you ask every single Lane Myers supporter out there, they'll say, we support the Constitution. The Constitution says this. And if you ask me, I say, I support the Constitution, mostly. I'm actually technically a monarchist, but, you know, But I'd say, yeah, I support the Constitution. Sure. I mean, it's what we got, and I support it. But what does that mean? I fundamentally disagree with the Lane Myers supporters in their interpretation of the Constitution. So what does support mean? We both say we support it. What does it mean? You don't know. I don't know. It says that she'll bear true faith and allegiance to the same. What does that mean? I don't know. Defend them against all enemies, foreign and domestic. Like if Arizona gets invaded, what's she going to do? Pick up a gun? I mean, but where, again, we're looking for something that says that she can no longer be alarmed, annoyed, humiliated, or mentally distressed. I don't see that in there. I don't see that anywhere in there. He says, therefore, he's presented no point other than stating the fact that she has signed this required document, this oath or affirmation for employees and officials. Okay. But what does it mean? You don't know. I don't know. And then he jumps. He makes this leap of logic out of nowhere that the following, therefore, the test is not a reasonable person, but the state of Arizona with an employee with a sworn oath to receive and accept criticism. Where did it say there? Did I miss that? Did I miss the part where it said that she would receive and accept criticism? And is there a difference? Is there a difference between criticisms and harassment? And where do they cross the line? Because the first time he contacted her, remember the first time he contacted her, first of all, he doesn't know what her job is. See the idiots. They say my First Amendment. I mean, it's like, I don't know. My First Amendment, case closed, problem solved. Fucking idiots. I love these guys. So he makes this logical leap. He says, so now the test is not reasonable person, but state of Arizona employee with a sworn oath. First of all, like citation needed. Where it doesn't say that in there. What case establishes that fact? What statute establishes that fact? Oh, there is none? Then why is that the test? You just get to make shit up. Like, bah, my name's Lane Myers and I make shit up. Oh, therefore the test is not a reasonable person test. Citation fucking needed. The court doesn't have to defer to Lane Myers, page 42, line 12. He's literally just making shit up. And you don't get to do that. The court doesn't have to consider that. Anything thrown out like this, just bleh, without citation to authority, meaningless, useless, garbage. All he had to do was find a single case that said, hey, on a harassment claim, if you're harassing a Arizona employee with a sworn oath, that sworn oath means, number one, that they will accept criticism and public scrutiny in the course of their employment in the public sector. That would be great. That'd be a start. He didn't do that. So it's a meaningless statement. Meaningless statement. Absolutely meaningless. There's zero things to support it there. He says, the following relevant material facts are the actual factual happenings in this instant case. Not the state's convoluted and misleading attempt to obfuscate the facts in their response. That's a meaningless 2 sentences. Those are meaningless. All he's saying is, no, really, I'm not lying. The state's lying. Great. Show the court. Don't tell the court. He says, Matt Walker, Shannon's husband, prosecuted Mr. Myers for booing at a Tucson City Council meeting. Irrelevant. Move to strike. Matt Walker is not a defendant in this. None of the charges are for harassing Matt Walker. It is irrelevant, immaterial. Move to strike. He says, Mr. Myers found a continuing ed class by Matt Walker on the AAPAC website and how to weaponize disclosure against defendants. He listed Shannon Walker on the AAPAC website. Okay. And does that mean that because Matt Myers listed her, that now all of a sudden you get to harass her? I don't think it does. I'm going to go out on a limb here and I'm going to guess it doesn't. Gonna guess it doesn't. Do I think we need a king? I think a king would be better. Yes. I mean, you could have a bad king, but you could also have a good king. You could never have a good Congress. You could never have a good president. Too many idiots, like Maynard votes, yeah. You can have a good king, but you can never have a good representative democracy or republic or however you want to phrase it. Because you got people voting like Maynard. Do I think it should be inherited? I don't know. I don't know about the inheritance. I'd be fine with, trial by combat. Everybody fight to the death to be king. Who wants to be king? I'd separate it out real quick. Every time a king dies, fight to the death. The strongest man wins. All right. So anyway, that's enough of that nonsense. So again, this doesn't mean that all of a sudden, because somebody listed Shannon Walker on a website, doesn't mean that he gets to call her and harass her. He says, Mr. Myers Googled Shannon Walker and discovered she was an Arizona Board of Regents employee with a loyalty oath. Well, congratulations. Doesn't mean shit. Count 7, September 12th, 2024. Since Shannon Walker had a duty to defend the Constitution against all domestic enemies, Mr. Myers reached out to inform her that her husband, Matt Walker, was in violation of state law and the Constitution. Well, so here's the problem, Myers. Here's the problem. Your opinion, much like Maynard's, doesn't mean shit. It's literally meaningless. Lane Myers is not an arbiter of who has or hasn't violated a law or the Constitution. He's not. I would love to see him report Matt Walker to the police and have the police take action. Now, I know what all the Lane Myers supporters are just going to say. They're going to say, but the police are corrupt. Right. The entire system is corrupt. The entire system has it out for Lane Myers because everybody gives a fuck about Lane Myers. Well, not really. No one really gives a fuck about Lane Myers. I mean, I think he's interested. Maynard says, you're not even licensed in Arizona. That's correct. I am not. Thank you for pointing that out. I am not licensed in Arizona. I am, however, licensed in California. I have taken the state bar and passed it in a state. There are lots of questions on the multi-state, the MBE portion of the bar exam, multi-state bar exam. So I'm in a reasonable position to be able to read and understand the statutes. And I also have, a full year of being a family law attorney to give me a good feel on how things actually operate in the courtroom. And I have done a couple criminal cases. So yeah, there you go. But this is nonsense. This is nonsense. It is not an excuse to say, I think your husband committed a crime, so I'm instructing you to what? Pick up a gun and go arrest your husband? She doesn't work for Matt Walker. Like, and show me any case that says that people who sign that oath have to go and arrest their husbands because some random fuck on the internet has told them that their husband is a criminal. Show me where. He says 6 hours after contacting Shannon Walker, Mr. Myers' wife, who is not his wife, was fired as a judicial law clerk for District Judge Angela Martinez and was told it was because of Mr. Myers' criticism of public employees in the Tucson legal community. Objection, hearsay. Double hearsay. Because this is not just a hearsay of what Shannon Walker said hearsay of what Lane Myers' girlfriend, who he doesn't even identify appropriately, she is reporting this to Lane Myers. So that's one hearsay level. The second level is what was allegedly told to the wife from someone else. That's the second level of hearsay. So we have at least 2 levels of hearsay. And unless it was from Judge Angela Martinez herself, there'd be a third, maybe a fourth level of hearsay in there. So it is something that the court should completely ignore. It is levels and levels of ignorable. He says on September 23rd, 2024, Mr. Myers made a video about Matt Walker and his continued malicious prosecution of Mr. Myers. He showed the University of Arizona website displaying Shannon Walker, a Board of Regents employee with a loyalty oath. He did not tell anyone to contact her. Well, so again, the court can draw inferences, number one. But number two, what does this have to do with shit? What does this have to do with shit? What does this have to do with overbreadth? What does this have to do with vagueness? He's arguing his case. He's so stupid that he can't contain his argument to the First Amendment. He can't contain his argument to the First Amendment. But even if he did not tell anyone to contact her, that's not a requirement. If the state can prove, and this is a matter of proof, if the state can prove that he did it for the purpose of having people contact her, because why? What is the relevance of that? What is the relevance of that website and her contact information? Like, why don't you give us a legitimate reason, a non-harassment reason for displaying it? What legitimate reason would you have? What legitimate reason would you have? None. He has none. And everybody knows he has none. So the fact that he didn't tell anybody doesn't mean shit. But again, this has nothing to do with the First Amendment. And by the way, also, the jury is going to get to color this count 8 with the initial contact and the subsequent contacts. All of these things are building together. That's why it might not have been to Lane Myers' advantage to combine the cases. it might have been a better idea to sever the cases, to sever the counts, and have multiple smaller trials to make the argument that it's going to prejudice the jury. Because that first, I've listened to the first voicemail, and I'm not trying to convince Lane Meyer supporters of shit. They're not smart enough, honestly, to learn from it. They're full fucking retard. But everybody who's not a Lane Myers supporter, who's listened to that first voicemail left by Lane Myers, it's a harassment. It is just on its face harassment. And so that's going to color everything that follows. That level of vitriol, what are you going to do to take down your husband? If you don't do something, I'm going to get your husband fired and yada, yada. Well, yeah, unfortunately it's not a crime to be stupid. They get to breed and they get to vote. But again, this has nothing to do with why the statute is overbroad or vague, etc. He says on October 2nd, 2024, Mr. Myers made a video about Samantha Walker, Pima County attorney, not Shannon Walker. Mr. Myers did not display Shannon Walker's contact information. Nobody fucking cares. On October 8th, he made a video about Matt Walker's 47-page improperly filed Rule 11 motion. At the end, Mr. Myers stated he was going to go interview Shannon Walker about Matthew Walker's unethical behavior and his wife's firing. Right. So again, just taken by itself, like if this wasn't in context with everything else, that probably would be fine. I mean, hashtag, your mileage may vary. Depends on how he says it, the language he uses, blah, 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 blah. But just on its own might be fine. But take it in context with everything else, it gets bad. It gets bad. And again, absolutely fuck all to do with the First Amendment issue. On October 9th, Mr. Myers went to the University of Arizona to speak to Shannon Walker about the matters of public interest related to her employment as a state of Arizona employee. No, he went there to talk about Matt Walker. The phone call was about Matt Walker. This video about Matt Walker, where he says he's going to go interview Shannon Walker. Well, the video, he says he made a video about Matt Walker. So he doesn't know what she does. He doesn't know the things that she's done. Like if he knew what she did and he had an issue with oh man, you use the wrong TPC report cover page to fax this document, and you should have used the right cover page. And I mean, that'd be different, but he's contacting her about Matt Walker. And so then he says on October 15th, Mr. Myers, and again, not fuck all to do with the First Amendment. Like these are just, he's just arguing his case. He's just arguing his case. He's not arguing a motion. He's arguing his case. On October 15th, 2024, Mr. Myers called Shannon Walker to gather information about Matt Walker's unethical behavior and his wife's firing. He stated he could interview on the phone or in person. He stated he was not trying to hurt her. He just wanted information. Well, you know what is really convincing on a harassment charge is if you have to tell the person who's accusing you of harassing them that you don't want to hurt them. He knows that she's concerned about his behavior because he's telling her, I'm not trying to hurt you. Fucking crazy. On October 16th, 2024, called Shannon Walker again to try to gather information related to Matt Walker and his wife's firing. Made sure to convey again that nobody wanted to hurt her. Again, why would you have to do that? He knows that he's harassing her. Just seeking information on matters of public interest. He doesn't know what she does. He doesn't know any of the things she's done in her job. He doesn't know anything that's been done in her job. And he's telling her he doesn't want to hurt her. Dan Fissel asks if this motion can be used against him. I think technically it can. I don't think they need to. They have the underlying videos. But yes. So anything you say can and will be used against you. And one of the many advantages to having an attorney is that you get to have someone speak for you whose words can't be used against you. So, I mean, he screwed the pooch on so many levels by firing his attorney. But it's his life. He gets to live it, and it's his choice to make. He says that on October 17th, the process server improperly served IAH. I don't know what an IAH is. On October 18th, Mr. Myers went to Pima County Superior Court and self-served the IAH. I don't know what an IAH is. I don't know what an IAH is. He says on October 18th, Mr. Myers went on another YouTube channel to discuss being served IAH. IAH was not sealed and was therefore was public information. I think that might be the civil restraining order information. On October 21st, 2024, Mr. Myers made a video discussing IAH and showing the relevant laws making it unlawful. Mr. Myers specifically said, "Do not contact Shannon Walker." And again, this is something that a lot of YouTubers do in this particular arena, like they used to call it call flooding, right? And they like to say things like, don't call, I'm just posting this publicly available number. Don't call it or anything like that. Don't call it. Don't call it or anything like that. And it's absurd. That kind of argument doesn't convince kindergartners. It doesn't convince kindergartners. Then he says on November 14th, 2024, during contested injunction hearing, Judge Griffin explicitly stated that no previously posted videos had to be removed due to them being First Amendment protected activities. I don't recall her saying that. I recall at the arraignment hearing, there was discussion of him pulling down videos about Shannon Walker. Now, injunction against harassment. Thank you. I figured it was related to the civil harassment restraining order. Yeah, those were all over the place. So I don't know what the actual order after hearing, what the judge's order was, or what the conditions of bail were. But I did listen to the hearing and the discussion being held, and Lane agreed to remove the ones that had Shannon's information in it, the victim's information in it. I believe he agreed to remove some of the videos. His attorney said he would remove like all of the videos about it. Lane clarified it down some, and then the judge kind of was like, yeah, but it was vague on the recording. So I'd have to see what the actual order after hearing was. But again, this has nothing to do with the First Amendment. He's just arguing his case. December 2024, filed appeal of the IAH with Division II Court of Appeals. I have not seen that document. I would love to see the injunction against harassment appeal. Am I blocked? You should be. Just for asking the question, you should be blocked. I haven't seen the appeal. It would be interesting to see the appeal, because again, in the civil harassment restraining order hearing, I think that there were some serious issues that he should appeal, like the references to the criminal harassment, to appellate opinions that are dealing with the criminal harassment statute, not the civil harassment statute. And since they have different definitions of what harassment is, I think they're inapposite. The other issue was that the court was using unpublished cases, and I don't know. I mean, again, I don't practice law in Arizona, but there are some serious appealable issues in the civil harassment case. Now, I don't know if Lane is going to be competent enough to prepare a good appeal, and with the way he behaved, the Court of Appeals might look for a way just to deny it, because the appellate court, they're human, and they might be like, hey, And then he says, in early January 2025, a confidential PIMA Superior Court source provided information related to case number whatever involving an IAH Shannon Walker filed on October 9, 2024. It was unlawfully dismissed and reissued on October 10th. Again, none of this has to do with the First Amendment. Then it says, ordered a copy of the FTR. From court reporter FTR. I'm going to guess this is the court reporter's transcript. Mr. Myers was provided 4 separate hearings by Tracy Johnson. Okay. Again, what this has to do with his First Amendment issues, don't know. He posted the FTR of the ex parte injunction hearing. She lied 33 times in 9 minutes under oath. Well, so where has a judge made that determination? Where has a judge made that determination? The finder of fact apparently found her to be credible. And congratulations. The fact that the way the civil injunctions work in Arizona, as best I understand them, is you get an ex parte hearing and the court will grant or deny based on that. It gets served, and then if the restrained party disagrees, then the restrained party can essentially ask for a trial. And it's at that trial. So that trial is the win, lose, or draw. It's the win, lose, or draw. Nothing that happened or was said at the ex parte hearing matters, because this is a trial. This is a fresh, clean slate. The plaintiff gets to present her case. The defendant gets to present his case. And then based solely on the facts presented at that trial, the judge will either grant or deny the restraining order. So all of this, irrelevant. It's irrelevant. On January 24th, Mr. Myers posted all 4 ex parte injunction hearings in one video. All 4 hearings were provided by Tracy Johnson. Congratulations. He's a party to them. And just because you're a party to it, I mean, I would expect you to be able to post those because they're yours. And they're a hearing that is related to you. In California, we have, it's a privilege. It's called the litigation privilege. And essentially anything you say in litigation, well, no, the litigation privilege wouldn't apply to this. But it would be a public record, right? It would be a public record. I don't understand what. I don't know. I don't know if that was a. Well, okay, all right, no, okay. So if all right, let me rephrase this. So this count 4, if taken by itself, just pulled out without any of the preceding issues or any of the subsequent issues, just this count pulled out, right? Probably not harassment. Probably not. It'd be hard to prove harassment. But again, the problem is that you have a series of events which are going to be viewed together. They're going to be viewed together. And that series of events is going to color all of the other events with the spiciness of each individual events. It's like a stew. If you just have a piece of meat, well, you don't have a stew. But if you have a piece of meat and you have some carrots and some celery and some onions and some mushrooms, and you put it together with some Lipton soup mix and water, and you put it in your slow cooker, all of a sudden you got stew or whatever, like they've got a lot of counts of stew. They've got a lot of counts of stew. It's a real problem. It's a real problem because again, like this by itself, if all you done was this and you hadn't done some of the other stuff, well, I'd say you have a good case of getting out of it. But The problem is that all of the other things, this is just these are all the straws that are breaking the camel's back. On January, he posted a video discussing his lawsuits being filed against Pima County, City of Tucson, University of Arizona, Stacey Ruprecht, Jane, Shannon, and Matt Walker. What's he suing Shannon Walker for? He's got nothing. He's got nothing to sue her for at this point. Myers called various U of A law school employees, encouraging them to investigate Shannon Walker lying under oath. Again, it's this whole idea that like everybody's his personal police force, and all he has to do is say, this person committed a crime, go get him. And every single state of Arizona employee or any subdivision thereof or any school district thereof has to jump their happy asses up and go march to Lane Myers' tomb. Why? Why would he think that? Show me one case that interprets that oath to be that way, where you have to dance to Lane Myers' tune because Lane Myers accuses someone of committing a crime. All of a sudden, every single state of Arizona employee is bound by their oath to go out there and do his bidding. It's fucking retarded. On February 22nd, Myers posted a video containing all 4 ex-parte injunctions while discussing at length the level of perjury and unlawful actions by Shannon Walker and judges Don Weiland and Don Walton. Well, you know, I mean, it's never a good idea to just cast aspersions at judges. Judges are judges, and just identifying judges randomly, like, oh, every judge I've been in front of has lied. They're unlawful. Every single judge I've been in front of has lied and been unlawful and done unlawful things. Oh, and by the way, Judge, I'm going to have you recused because you're doing unlawful shit. Ridiculous, retarded, and ridiculous. As this court can see, all 3 voicemails before injunction was served addressed behavior by Matt and Shannon Walker. Well, yeah. So, but why was Shannon Walker in this ex parte hearing, getting a restraining order? Why was she there? Again, this all started once again with that voicemail that you left, contacting her, basically telling her to go after her husband, like any wife is going to do that. Happily married wife, I should say. That call was harassing, and that's going to flavor everything going down the line. Everything. All voicemails involve matters of public interest and were protected by both Constitution and state law. That's an assertion without any support. Show me the cases. Show me a case that has a similar fact pattern. Show me a case that says a Board of Regents, whatever employee, has to jump to your tune and confront prosecutors in your criminal case because you allege the prosecutor is doing something unlawful. Show me the case. Oh, you don't have one because it doesn't exist. Well, that's a real fucking problem. This motherfucker saying, do your own research. It's not my motion, bro. It's not my motion. It is Lane Myers' job as his own attorney, you stupid fucking retard, to do the research, to place the case law in front of the judge so that the judge can make a good decision. He did not do that. That's the point of this video, you stupid fucking moron. He failed. And you're so dumb that you don't even understand that he failed. It's absurd. He's just making claims without any authority. Statements of law that don't have any authority to back them up are not statements of law. The court can ignore them. The trial court is bound by the decisions of the courts of appeal and the Supreme Courts. Okay? He's bound by it. That's why you present it. The trial court is bound by the statutes. That's why you present them. The court doesn't have to do what the fuck Lane Myers wants. And Lane Myers is saying, it is because Lane Myers said. It's stupid. It's stupid, and you're stupid for believing it. And you should feel bad. And I hope you don't breed. And I hope you don't vote. All videos before IAH and after showed the actions of public employees during public hours, either in public court hearings or in the course of their duties as public employees with the loyalty oath pursuant to ARS 38-231. Again, this is that They have the oath. Okay. And again, what case, what statute says that there is a different standard applied to them than non-public employees? And he missed that leap. He missed that leap. Well, he made that leap, but he didn't provide any bridge for anybody else to get across with him. This was clearly, that's my favorite word. Whenever a lawyer puts clearly in a pleading, he doesn't have shit. Whenever a lawyer puts clearly in a pleading, he doesn't have shit. Clearly, obviously, I mean, it's bullshit. It's like you're trying to emphasize, or when they bold and underline, when they bold and underline, that's also a sure sign that they don't have shit. So just by putting clearly, putting emphasis in there, it instantly, I'm like, okay, you got nothing. Prepare for the bullshit, boys. It's piling in. This was clearly a particularized message. Okay. Very much understood by those who viewed the videos. Well, apparently not, because multiple judges have viewed the videos, and at least one grand jury, 2 grand juries have viewed the videos, and they came to a completely different opinion. So the reactions, comments, and popularity of the videos indicate the public is very interested in holding public employees accountable for their actions undertaken in the course of their official duties. Just because a video is popular doesn't mean it's not harassment. There is nothing in the statute that says popular videos cannot be harassing. And if there is, show it to me. You can't, because it doesn't exist. Which is why he's making random statements of, air quotes, law without actually providing any law. As this court can see by the state's response, they have continuously avoided the elephant in the room. Oh my gosh, there's an elephant in the room? He's referring, of course, to the loyalty oath. The fact that Shannon Walker was a state of Arizona employee with the loyalty oath, this sounds oddly familiar. Haven't we read this before? I think we have. Pursuant to blah, blah, this important material fact means Mr. Myers, did he put the same page in here twice? Or did he just... Or am I just going crazy? I'm going crazy. So we've addressed it, but we're going back to it, I guess. This important and material fact, well, show why it's important and material. Don't just say it is important and material. Show it. Show me. Means Mr. Myers' communications towards and about Shannon Walker were protected by the Constitution of the United States as well as the Arizona Constitution. Citation needed. This would be where you put in that citation. This would be where you put in, see this case X where they held this. See this statute where it says this. See this case where it said this. This is where you show it. Not just say it, show it. By attempting to obfuscate the facts, by creating a narrative that Mr. Myers only contacted Shannon Walker about his wife being fired is disingenuous at best and prosecutorial misconduct at worst. I don't think it is, but I also don't think that their narrative is that Myers only contacted Shannon Walker. Where's that Jack Zwack guy or Jason Zwack guy? Well, if he only contacted her about this, I think the state's position, especially since they filed charges to the effect, where the initial phone call happened as well. So, Mr. Myers contacted Shannon Walker prior to his wife being fired about her husband's unlawful prosecution of Mr. Myers. Again, why is that relevant to her? Why does she get to be contacted every time someone has an issue with her husband's prosecution? Because remember, her husband is a prosecutor. It is his job, as the title would suggest, to do prosecutions. I'm going to guess that 100% of every single defendant in those prosecutions doesn't like the job that Matt Walker does prosecuting them, because they are the unfortunate recipients of Matt Walker's prosecutions. So does that mean that Shannon Walker has to go through life getting contacted by every fucking asshole on the internet because some dude is getting prosecuted by her husband? Like, where does that make sense? Where does that make sense? Where Where does it say in any fucking statute or in any constitution anywhere that you get to harass somebody's wife because you don't like the way they're doing their job? Fucking crazy. This led to his wife being fired. That is an allegation that, first of all, is irrelevant, and second of all, is based purely on at least 2 levels of hearsay. And Mr. Myers then, looking to gather information related to her being fired and his belief that Shannon Walker was involved. Well, okay. But see, he's already started the harassment. And now he has an additional reason to harass her. And a jury can look at this and be like, well, you know, he was pretty harassing to her when it was just her husband prosecuting him. And now all of a sudden, he thinks that this gal got his wife fired, who doesn't even work for the University of Arizona. Like, how the fuck does this even? And wait a minute, I thought she got fired because he was criticizing. Hold on a second. Hold up. Wait a minute. I still got my dick up in it. Now, up here, he said that that Mr. Myers' wife was fired as a judicial law clerk for District Judge Angelo Martinez and was told it was because of Mr. Myers' criticism of public employees in the Tucson legal community. Where in there is the indictment of Shannon Walker? Where in there is the indictment of Shannon Walker? Where is it? In the initial phone call that he made to Shannon Walker, he was very abusive towards her husband, but he didn't criticize her performance and her job. He doesn't even know what her job is. I mean, let's be honest. Well, I guess he knows what her job title was. I don't know if he knows what her new job title is. Probably does. I don't know. Doesn't matter. Don't know. Don't care. This was a very particular message being conveyed. Now, he seems to think that conveying a particular message is somehow relevant. Well, cite the fucking case. Cite the case. Cite the case. Cite the case. Cite the case. It says that if you give a particular message, that can't be harassment. You see where this is going over and over again? Oh, legal authorities. All right. In deciding whether particular conduct possesses sufficient communicative elements to bring the First Amendment into play, the Supreme Court has asked whether, quote, an intent to convey a particularized message would be understood by those who viewed it. Right? Right? So that's a thing. Okay. So is the First Amendment in play? Maybe. But are you being charged with communications, or are you being charged with harassment, which is conduct? Huh. Some examples of expressive conduct. Okay. So again, conduct. So what State versus Brown was looking at, I'll let the cat out of the bag. This is State versus Brown. This isn't State versus. Yeah, this is State versus Brown. This is State versus Brown. So it's just a different. This is the Pacific publication. It's a different publication than the official one. But what they're looking at here is, first of all, they come to the conclusion that these are conduct restrictions. So they're looking at conduct. This is a conduct restriction, right? They're looking at conduct. So he's taking a quote from State versus Brown out of context, which pro-pers and soft sits love to do, where they're trying to say, look, is this conduct First Amendment speech? And this goes back to what's the draft card burning case? Oh God, what's the name of that case where he burned the draft card and they're like, is this speech? Do we even have to do a First Amendment analysis on it, etc.? But anyway, regardless, he's applying this language to actual speech, not conduct. But there's also conduct. I don't know if that makes sense. So in State versus Brown, they were looking to see if conduct. First of all, the starting point is, do we have to do a First Amendment analysis? Because it's conduct-based restriction. And then, is this conduct speech? Yes. Then we do a First Amendment analysis. And they looked at the statute, State versus Brown. They looked at the statute and they determined that it was in fact constitutional because there was an intent element in it. And we'll get to that. Some examples of expressive conduct, which is why they go on here. Some examples of expressive conduct found to contain a particularized message to burn a U.S. flag by a protester at the Republican National Convention, the wearing of black armbands to protest Vietnam War, and conducting a sit-in by African American persons against a liberties segregation policy. In all cases where a particularized message has been found in expressive conduct, there's little doubt from the circumstances of the conduct that it formed a clear and true particularized political or social message, very much understood by those who viewed it. Great. Now, apply the facts to this. But he doesn't. He just goes on to another argument. This is another argument he has. Statements about two third parties about an individual, even if offensive or defamatory, do not constitute harassment under Arizona law. LaFaro versus Cahill. Now, LaFaro versus Cahill, the defendant was talking to people, not LaFaro, talking shit about LaFaro. There was no indication in that he was asking those people to talk to LaFaro, and he was not intending for LaFaro to overhear. So what the state has to prove is that there was a person commits harassment if the person knowingly and repeatedly commits an act or acts that harass another person, or the person knowingly commits one of the following acts in a manner that harasses. And this is the one that they charged him under for most of them. Contacts or causes of communication with another person by verbal, electronic, mechanical, telegraphic, telephonic, or written means. So, Lane Myers, by putting her phone number up there, caused other people to contact her, and the state has to show that he knowingly put it up there. He put it up there knowing that people would call her to harass her. So that's a burden of proof on the state that I think they'll be able to meet, but maybe not. You never know. But it's a different situation than LaFaro versus Cahill. LaFaro versus Cahill is the closest case I could find on point, but it's distinguishable because the issue in LaFaro versus Cahill wasn't the defendant trying to get other people to contact LaFaro. Issuance of an injunction against harassment requires the defendant engage in a series of acts of harassment that were directed at a specific person. So LaFaro versus Cahill was a case that involved the civil statute. Let me pull it up here. So LaFaro versus Cahill, you see that this is involving the civil statute. This is the injunction against harassment, right? This is an injunction. This isn't criminal. And remember, my big condemnation, my big criticism of the court in the injunction against harassment, the civil one against Lane Myers, was they were using opinions that dealt with the criminal harassment statute, which is a completely different harassment statute and defines harassment different, when they're adjudicating a civil harassment issue with a different definition of harassment. And that Lane Myers is making the exact same mistake here because he's citing to a case that deals with the civil harassment statute. And it goes on to say issuance of an injunction against harassment requires the defendant engage in a series of acts of harassment that are directed at a specific person. Right. Now, the court found that there was one or more acts because Lane Myers contacted her at least once, left at least one voicemail. He also went to her place of employment. He also directed people to contact her. So there was a series. And at a minimum, there was two, because he went to her place of employment and he called her. Further, the statutory definition of harassment requires a harassing act to be directed at the specific person complaining about harassment. Right. So again, that is the civil harassment statute. So I don't even know why the fuck we're talking about this. Talking about an individual and expressing one's opinion of that individual's acts, especially when those acts are public or political in nature, is not harassment. Again, this is the civil. Arizona's harassment law cannot be used to restrict protected political speech. Again, that's the civil. Speech about court proceedings and active litigation, while perhaps not overtly political, logically falls within the same category as political speech because it involves matters of public interest and concern. The citation there would be awesome. No citation given. That makes me suspect that there is none. Court records and court proceedings are matters of public record. That is true. But again, a citation would be great. There are some court records that are not public and are not publicly available. There are sealed public records. So, there's that. And he says, no legal precedence restricts an individual's ability to discuss active, ongoing litigation in unsealed proceedings. Sure, but if you're harassing someone, then you can't do anything harassing. Even, for example, making noises, banging a drum. Oh boy, more fun for tomorrow. So there doesn't have to be any communication to be harassment. And it's conduct issue. So, but again, all right. So in denying Brown's pretrial motion to dismiss, Judge Dolly reasoned, this is language from State versus Brown. Where does it say it in here? Here it is. So this is what he's quoting, but you'll notice that this is not in the actual part where they're jumping into the First Amendment challenge issue and where they're going in the vagueness but over breadth claims. So we'll see what he does there. So none of this is all dicta. He says clearly the trial court found the only reason. So the trial court found that the only reason why the ARS statute was constitutional was because it contained the requirement of intent. Why the trial court found anything is immaterial and irrelevant. This trial court is not bound by that trial court's ruling. This trial court is bound by the appellate decision in State versus Brown, but not the trial court's decision in State versus Brown, if that makes sense. Moving to the appeal court, which is prudent. I don't know why you waste anything on the trial court. They made similar findings of the intent requirement being the only thing that saved the statute at bar. Right. Indeed, interpreting the statutory language to permit prosecution for constitutionally protected activities would require the state and the courts to expand the statute to reach considerably beyond what the legislature intended. Accordingly, any misuse of the statute, if such occurs, can be addressed and cured through case-by-case analysis of specific facts. Now, where does it say that in there? So what the court is looking at here is if it is an otherwise on its face valid statute, vagueness and overbreadth claims, on its face valid, that and all of a sudden it gets misused, they would then look at it to make determinations case by case. But they're quoting so this is part of the overbreadth claim. So apparently the defendant, Brown, the appellant, said that there might be some issues where this could be reach impermissible statutes. He provided no indication that likelihood exists the state would use the statute to reach such activities. And if it does, then they'll look at it on a case-by-case basis. But again, on its face, it is not overbroad. Yeah, so it continues. As this court can see, and must find in this instant case, the only reason the statute was ruled constitutional in State versus Brown was their inclusion of language with intent to harass, in quotes. Well, I have the statute. This is the 2005 version. This is what the court was dealing with. This was valid. This is the oldest one I could find. This is the actual language, though, that was used. So a person commits harassment if with intent to harass or with knowledge that the person is harassing another person. The person anonymously or otherwise communicates to the person by verbal, blah, 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 in a manner that harasses, yada, yada, yada. So this was the original language. But notice it's with intent to harass or knowledge that the person is harassing. And indeed, in here, when they actually talk about the language of the statute, where's the language of the statute? That's the overbreadth. Here we go. So under 132921A1, a person commits harassment if with intent to harass, and then or with knowledge that the person is harassing another person. Those are two different mens rea requirements. They're two different mens rea requirements. And those two different mens rea requirements are still present in the statute today. So, well, no, they've gotten rid of the intent, but they still have the knowingly. So a person commits harassment if the person knowingly and repeatedly commits an act or acts to harass another person, or the person knowingly commits any one of the following acts in a manner that harasses. And there would be contacts or cause of communication with the person by verbal, electronic, mechanical, telegraphic, telephonic, or written means. So the standard of proof there is knowingly, and ARS knowingly definition. Knowingly. Culpable mental state means intentionally, knowingly, recklessly, or with criminal negligence, intentionally or with the intent to, with respect to a result or to conduct described by a statute defining an offense. The person's objective is to cause a result or engage in the conduct. They took that out, but they didn't add, they left in knowingly. Knowingly means with respect to conduct or to a circumstance described by a statute defining an offense, that a person is aware or believes that the person's conduct is of the nature or that the circumstance exists. It does not require any knowledge of the unlawfulness of the act or omission. And knowingly describes, in my interpretation and understanding, knowingly describes what Myers did to a T. To a T. So it doesn't require, quote, with intent to harass. It doesn't require, quote, with intent to harass. It required, past tense, with intent to harass or with knowledge that the person is harassing. And it still requires knowledge. The person knowingly and repeatedly commits an act, or the person knowingly commits any one of the following acts, and one of those would be to cause a communication with another person. by verbal, blah, blah, blah. So not a good argument. Since the 2022 removal of the word intent, the statute can be used in an overly broad and vague manner to prosecute the very same activities that the court found the word intent would protect from prosecution. The problem is the court was dealing with the statute where they could prosecute under knowingly. They could prosecute under intentionally or knowingly, and now they could still prosecute under just knowingly. So there is no substantive difference between the prior statute and the current statute. Without the word intent, this court must find the statute unconstitutionally vague and overbroad, both on its face and as applied to Mr. Myers' current prosecution. The as applied argument was pretty weak. This finding is in line with the legislature currently amending ARS yada yada to include the word intent and prohibit the prosecution of people who criticize public employees. If they just add the word intent back, all right. Bills. Active bills. Let's see if we can find it. Does anybody have a link to it? I saw it before. Amend 13-2921 intent. Wow. Knowingly commits one of the following acts with the intent to harass another person. Wow. So they're mixing two mens rea elements. That doesn't make any sense. I don't understand what the legislature's doing there. Because that doesn't make any sense. Knowingly commit an act with intent. Because again, intentionally or with intent to is a different mens rea than knowingly. And knowingly with intent, what the fuck, dude? It doesn't make sense. Does not compute. Oh shit! Oh, God damn it! I'm just going to delete the stream, I guess, when this is done. There's all sorts of public whatever. I'm just going to delete the stream. I spoke with Ms. Walker this morning to clarify her blah blah blah. So she's now working. What does this have to do with it? She's now working with a 501c nonprofit organization. Great. This is a narrative by Detective Brown or Officer Brown. They wanted to add another post live video, which discussed the order itself is titled blah, blah, blah. Reports. He also mentioned for people not to contact the plaintiff in that incident. Yeah. See, she even said he also mentioned for people not to contact the plaintiff in that incident. Everybody knows that that's a dog whistle to contact the person that you're saying not to contact. Stop and arrest for IJP removed from the system. Okay. And then Lane emailed Matt Walker. I do not condone those crazy messages in any way. Well, if he says he doesn't condone it, I mean, problem solved. I mean, I didn't, Your Honor, I didn't mean to kill that person. Your Honor, I didn't know that she'd withdrawn her consent when she maced me. I didn't know that. I mean, I would never have continued on with the SA if I knew she had withdrawn her consent. You got to remember that this is something that he said, right? Nothing you say can be used by you, but anything you say can and will be used against you in the court of law. Whoops. Whoa. I wasn't sharing it. Ha ha. Hold on a second. Does that mean I didn't share the bad thingy? I didn't share the thingy. Yay. Because of my ineptitude, I didn't share all the bad thingies. So yay, go team. So yeah, just him saying that doesn't change anything. All right. So anyway, I didn't dox the crap out of him because at the end I'm going to switch to this one, share this tab instead, go back and look, and yeah, at the end of it he had, I guess, his home address, which is stupid. Like, you're supposed to have the address where you can receive mail, and how is he going to receive mail at that address if he's in jail? So anyway, yeah, so it wasn't a well-written reply brief at all. He cited cases that were inapposite. He made logical leaps that weren't supported by case law or anything. And yeah, I mean, I just assume we're going to see more of the same. Anyway, I thought it was fun and interesting to look at. I hope you enjoyed it. I hope you learned something. If you're a Lane Meyer supporter, obviously you didn't, but I don't do these streams for you. I do these streams for the sane, rational people. Thanks for watching. Have a great day.